So indemnification, this is a really hard concept to understand. So we're going to break it down, okay? You're welcome. We're going to break it down. So when we're talking about indemnification, we're really talking about an issue with three different parties, right? There are two parties, the two parties who have the contract together, right? So in this case, let's say it's the venue and the organization that's holding the meeting. And then there's a third party that can claim damages of some kind, okay? And that third party goes back, right, with the intention of collecting money going to court, right, goes back to the two parties in the contract and sues them. Okay, so when you think about indemnification, think about the three parties, the two parties who are in a contract with one another, and the third party who had some sort of damage done to them. Okay, so now I'm going to read the definition, and then we'll move forward. I think that by the time we're done, and we're going to go through about 20 slides, and so that you can get this. By the time we're done, I think you'll understand it. Okay, so indemnification is a contractual promise in which one party agrees to protect the other party. Those are the two people in contract with each other from liability as a result of a third party, the person who says they're damaged, of a third party claim based on negligent or wrongful action or omission of the indemnifying party of it or its employees, contractors, or agents. So the first thing that we need to know is that indemnification should be mutual. In other words, if you're in contract with somebody, you should be able to say, I'm going to indemnify you and you're going to indemnify my organization, right? That's the way it should go. If you don't see that, you better walk away, right? That is not a good sign. Okay, so that's a whole lot of legal jargon that's confusing. So I'm going to make it so that it's easy to understand, right? We have a planner, right, and a hotelier, okay? And the planner and the hotelier enter into a contract with one another. Fantastic, okay? So contract is signed. The hotelier is mopping the floor, and one of the attendees comes, trips and falls, right, and goes to the hospital, right? And because they have damages, they are seeking a lawsuit, right? And the parties that are involved are, right, are the hotelier, the planner, and the attendee, right? There's your three, right? Two that are in a contract with one another and one who wants to seek damages. Now, in this situation, right, the hotelier is at fault. They were mopping the floor, didn't put any markings out, right? They were negligent, right? And so therefore, the hotelier indemnifies the planner because the attendee, and actually they're lawyers, right? The lawyers are going to go after whoever has the money, right? And so that could be the hotelier, could be the planner. They don't know. They don't care. They're just looking for, right, a return on this lawsuit. Okay, so they're going to sue both of you, and the one at fault should indemnify the one who is not at fault. Okay, so one more time. Hotelier, planner, we've signed a contract together. Right now the planner is carrying their road case and they leave it out and the attendee trips and falls over the road case. This attendee goes back to the hospital, right? This time, right, don't we have different fault, right? So the planner is now at fault in this situation. They're going to indemnify the hotelier, right? Which is why we want it to be mutual. Okay, so hopefully that clears that up a little bit. So The purpose of all of this is to require one party to protect the other and to pay for any loss or damage incurred by the indemnified party for any negligent or wrongful action or omission of the indemnifying party or other agreed upon circumstances. They're not going to agree. Could be a jury case. It could be a solved by the judge. It's hard to know. Could be both situations, Sarah. Okay, so in some cases, the obligation may require the indemnifying party to engage an attorney and affirmatively defend the third-party claim, right? In other words, it's not my fault, but I have to do that, right? I'm being sued, I didn't do anything wrong, but now I have to hire an attorney, right, and deal with all of this. So when you see a clause that says indemnify and hold harmless, man, that's what you want to go for. That's the gold standard, because that really means that not only are they going to pay the results of the lawsuit, but they're also going to fully protect the other, including payments of costs and attorney's fees. So that's really what you want to go for.